You are audible.
Thank you.
You are very audible.
We can hear you.
My name appears on the first slide. I'm a practicing advocate of the High Court of South Africa. I also act as a judge at the Gauteng Local Division. Let's start, and before we start with our session, let's just have a few ground rules. If anybody is on the floor, please let us give them the opportunity to say what they would like to say without any interruption and particularly without any background noise. That means that whenever you're not on the floor, you're not speaking, kindly mute yourself. That's the first rule. Second rule, I will rely on you when you need a break. When you need to take a break, I don't have a difficulty, but I think we should try and coordinate the breaking so that we don't take a break when X needs a break and then 2 minutes later Y needs a break and we take a break. We are going to be together for the next 3 hours. The session is from 5:30 to 8:30. So good evening to all of you. Okay, the first slide is just talking about alternative dispute resolution, and it is intended to put out there what the legislative underpin is for this concept called alternative dispute resolution in South Africa. And in South Africa, as you all know, we have a constitution. A whole lot of the concepts that are operative out there, they have a constitutional underpin, and then flowing from the constitution, Parliament is then able to make laws that give life.
Hannah, sorry, we can't see your screen.
Remember what I said?
Sorry, I just entered. I heard you talking about slides, and so I thought maybe you were sharing a screen. Sorry.
No, I was saying you can't see my screen, but the coordinator advised me that she did email you all the slides. So you will be able to follow with me, to go with me as I continue. I will tell you when I change a screen. Every time I change a screen, I will say next screen. I'm sorry, next slide. All right?
Amen.
Okay. So the constitutional underpin for alternative dispute resolution in South Africa is Section 34 of the Constitution. It's where it says everyone has the right to have any dispute that can be resolved by the application of law decided in a fair public hearing before a court, or where appropriate. You will see in your notes that the parts that reads where appropriate, another independent and impartial tribunal or forum. I've underlined that, that's my underlining. And I underline that because it talks to exactly what we are here today to discuss, alternative dispute resolution. So having said that, and having given the constitutional underpin for ADR, I've already mentioned that a number of various pieces of legislation in various industries have been enacted by Parliament to give life to the constitutional provision, and there have been many industries that have picked up on the concept of alternative dispute resolution, and that has made it imperative that the legal profession must create and ensure a state of readiness to produce the requisite competencies in this area. Next slide. Please feel free, if anybody would like to stop me and ask a question, feel free to do so, and I will get an indication by seeing a hand on my screen. If I see a hand, or if I don't see a hand, please just advise me that there's a hand up, and then we will give that particular person an opportunity to say what they would like to say. In the next slide, we then look at alternative dispute resolution in various industries. It wasn't possible to put out there, to put in this presentation, to put all the industries that have got alternative dispute resolution mechanisms. But I chose those that are very much in our faces, and those that have been using this concept for a longer period than others. And one of those is the Commission for Conciliation, Mediation and Arbitration, the CCMA, which is an alternative manner of resolving disputes between the employers and employees, either individually or as represented by unions. And as I have said, the CCMA was established no later than 1995, straight after the Republic of South Africa became a democracy. It was one of the first statutes under the Department of Labor. It was one of the first alternative dispute resolution mechanisms that was put into place. That was during the period when Minister Tito Mboweni was the Minister of Labor, if any of you were around at that time. It was established then to conciliate workplace disputes. It was established to arbitrate certain categories of disputes which are not resolved via conciliation. As you can see, it is called the Commission for Conciliation, Mediation and Arbitration. So conciliation is the first step.
Sorry, Judge, I don't think we can hear you. It's muted on your side.
You've muted yourself, ma'am. Still on mute, Your Honor.
I don't know how I became muted because I did not mute myself. I hope that doesn't happen again. I was on the CCMA, which was established to also put together picketing rules. It facilitated and supported the establishment of workplace forums and statutory councils. It drew attention to itself, put out a lot of information into the public space, and aroused interest through publication of statistics of activities. In other words, every now and again, the CCMA would tell us how many cases it has heard and how many of those were awards in favor of employees, how many of those were awards in favor of the employers. It accredited and considered applications for subsidy by bargaining councils and private agencies. It provided support for the Essential Services Committee. The Essential Services Committee is that committee that decides which service
My lady, again, you've muted yourself or have found yourself being muted.
I haven't. Is somebody trying to speak?
My lady, I think your microphone is off. I can't hear you.
No, that's not me speaking. Somebody is trying to speak. I don't. I wonder, Zukisa, are you on the platform with us?
Yes, I am, and I'm checking whose mic is not muted. Everyone is muted. Everyone is on mute.
Can I ask you, please, to deactivate, because I think my microphone, my mic keeps getting muted. I don't know how, because I don't mute myself. I certainly want everybody to hear me, and I'm not able to sit on the MS Teams page because I've got to go through the presentation. Are you with me, Zugus?
Yeah, so I should mute everyone. I should deactivate everyone's mic.
No, I'm talking about my mic now. I'm asking you to please watch my mic. Once it gets muted, please unmute it, because I'm speaking. People need to hear me. Now, I don't know how it gets muted without me muting it, but there's a hand. There's a hand. Cora van der Merwe would like to say something.
Ma'am, 2 nights ago, exactly the same type of thing happened with another lecturer, and last night I saw that they deactivated her and they showed her status as not available. I think someone may be sabotaging. Some of us are here to learn, and some of us are here to take this seriously. So Kiswa, if you can just change the profile of the acting judge to show her as not available so that we're not subjected to these interruptions, please.
Can you do that, Sugisa, please?
I can't show her profile as not available because she has the rights, and I'll keep watch. I guess I have to just keep watch and then look at the mic, and also judge. Okay, we will give you a shout if maybe you are muted again. We'll let you know.
No, are you not able to unmute me?
Yes, I will unmute you when you are muted. But
yes.
if I can't, like previously, I tried to unmute you, but I couldn't. I will let you know.
Okay. The most important thing is for me to stay audible to the audience. And if there's a way of preventing this muting, because it's not done by me, I can't possibly be doing that when I need my audience to hear me, because I need my audience to interact with me. All right, let us continue, and let's hope this is not going to happen again. So I was just saying that the CCMA did a lot of work to try and make sure that the whole concept of conciliation, mediation, and arbitration is out there and is understood by people. And I was in the process of explaining what the Essential Services Committee is and what it does, and that's the committee that decides which services are essential services, and therefore those services need to continue working even on a skeleton staff basis, because we can't have, for instance, a to think of hospitals, to think of hospital staff not being at work, to think of staff in a ward, in say for instance a high intensive care ward, staff not being there because there's a countrywide strike is totally unworkable. To think of staff that work for SOEs like ESCOM, to think of staff that work in all these services that the country cannot run without, the people cannot survive without. The lives of people will be threatened if that particular service doesn't get provided on a continuous basis. That committee needed support, and obviously the CCMA was very much mandated to provide the support that committee needed. Whether that happened and how far it went, because there was some unhappiness between that particular committee and the CCMA at a certain point, and I do think and I do hope that things have normalized between that committee and the CCMA, given its important mandate. Let's go to the next slide. The next slide is now talking about the steps for putting your dispute at the CCMA. What are the practical steps that one needs to do in order for that dispute to be submitted at the CCMA? It depends on the cause of the complaint, the time period that one has to lodge the complaint after the cause to the complaint has taken place. If the complaint is about unfair dismissal, the complainant has got 30 days. If the complaint is about unfair labor practice, the complainant has got 90 days. And if the complaint is about discrimination, the complainant has got 6 months, within which, counting from the date of occurrence of the event that gives rise to the complaint, one has got that amount of time, and depending on what the nature of the complaint is. The case is lodged by completing a CCMA case referral form, which is called LRA Form 7.11. It's a form that one completes and submits it to the CCMA. I believe one is able to go to the CCMA, but also if you go to the website, to the CCMA website, this is a form that is also available for purposes of lodging a complaint with the CCMA. A copy of this form needs to be delivered to the other party being the party that is involved in the event that gave rise to the complaint. So that other party must get that form, and you as a complainant, you've got to retain proof of delivery so that you are able to prove that you have provided this particular party with your completed LRA Form 7.11. These two forms, the LRA Form 7.11 must be delivered to the CCMA in person, via the mail, in other words, postal mail, or faxed together with the proof of delivery to the other party. The CCMA will advise, because now the CCMA will be having both forms, the form that arises from the complainant and the form that the proof of delivery to the defendant, if you like to call the other side that, but I think the correct terminology would be the other party. The CCMA will then advise both parties of the date, time of the first hearing. The first meeting, which is the first hearing, this is now what is called the conciliation, which will be it gets attended by both parties. If there's a trade union involved and an employer organization, they will also attend. An employer organization would have to be there if the employer is a member of a particular employer organization, and obviously the trade union if the complainant is a member of that trade union. If the matter is not resolved at this meeting, at the conciliation meeting, the commissioner at the CCMA, the commissioner is the officer who chairs the proceedings. The commissioner issues the certificate, and depending on the nature again, the dispute is referred either to arbitration by the CCMA or to the labor court. Referral to arbitration also needs a request for arbitration for an arbitration form, which is called the LRA form 7.13, with a copy served to the other party. In other words, the same process with respect to the entry of the complaint must be followed by the complainant completing an arbitration form, which is called LRA form 7.13, with a copy served to the other party. Next slide. We're about to finish the labor process. The arbitration is a hearing similar to a court hearing. Those of you who haven't been in an arbitration before, it is very similar to an action, except that it happens in an office and it is chaired by a commissioner. There's no public attendance in there. It's only the parties that are concerned and their representatives, which should be a trade union and an employer organization if the employer is a member of a particular employer organization. So evidence is led in there. Cross-examination is conducted by both parties to one another, and the parties are allowed legal representation. Why it is important to specifically mention that the parties are allowed legal representation is because in certain employer industries, legal representation is not allowed in a disciplinary hearing. So when the parties come to the CCMA, they need to know that legal representation is allowed, except that you are also entitled, you are also very much at liberty to conduct your own case at the CCMA. You don't have to have legal representation, but if you need legal representation, it is allowed. After the completion of the process, the arbitration process now, the commissioner issues an award. Commissioner issues the award within 14 days. And if any party does not comply with the award, the same award can be made an order of the labor court. And once it becomes an order of the labor court, it means that non-compliance with that order constitutes what is it? Constitutes misdemeanor, contempt of court, a serious misdemeanor, which can land somebody behind bars, which can also land somebody with a fine, a serious fine from the court, from the labor court. So that is the process. That is the practical process that takes place with respect to the CCMA processes. I'm going to pause and entertain any questions if there are any, and if there are none, we will continue.
Hi, Judge. I have a question. I have my hand raised.
Okay, sorry, I can't see the hands now because I'm in the presentation screen.
No, fair enough. Judge, suppose that there's a dispute between a former employee and his erstwhile employer regarding benefits which accrue to the former employee during the existence of the employment. Will the former employee have the right to refer the matter to the CCMA?
Yes, certainly. If those rights or benefits arose during the period of employment, that matter will be entertained by the CCMA. And I just want to say, if the benefits, for instance, let's say the benefits are pension benefits, the employee can also take the matter to the pension funds adjudicator. There is an ombudsperson who is called the pension funds adjudicator, who looks after all pension fund complaints by ex-employees or current employees. But even the CCMA, I would imagine that if a matter like that landed with the CCMA would be seized with it, and at a point where the CCMA believes that this matter must go to the pension funds adjudicator, then they will refer the matter to the pension funds adjudicator. I see two more hands. I don't know which one was the first, but I see Mapula Ngwana and two others. Mapula? Mapula, you have your hand up. Would you like to say something? Okay, your hand has disappeared and is quiet. I see Adam Sibia.
Yes, evening, Judge. I just want to ask, where do we appeal if a client is not happy with the ruling or the award that has been awarded through CCMA, where we can appeal? Thanks.
Appeals from the CCMA go straight to the labor court. The labor court is at the level of, I would say, the SCA, but for labor matters. I would also say it also depends on the nature of the appeal, of what the appeal turns on. If the appeal turns on labor issues, then the appeal will go to the labor court. But if the appeal turns on matters that can be heard by the High Court, then the employee will perfectly be entitled to take the matter to the High Court. Have I answered your question?
Yes, Judge.
Adam?
Yes.
Okay. There's been a lot of hands. I saw Christopher, and I see now Cora from the Merve. I don't know who was first, but between Cora and Christopher came first.
Just thank you so much. My question relates to cost and referral of Section 173, where in
So you sound a bit muted. It sounds like there's something between you and your and your screen. Can you take the volume a bit up, just a bit up, so that I can hear you?
Am I audible now?
Okay, I think please continue to speak. Maybe I will hear you as you continue.
Okay, Judge, I was saying mine relates to section 187 referrals, wherein parties in a dispute agree to take the matter for arbitration instead of the labor court. I just want to check whether in case where an arbitration is not in favor of either party, does it still go to the labor court? Is it still allowed even when parties have agreed that they will arbitrate instead of starting at the labor court? The second question is in relation to costs at the CCMA. Are parties entitled or can they argue costs at CCMA? Thank you.
Yes. To answer the last question, yes, parties are perfectly entitled to argue costs at the CCMA, and the commissioners at the CCMA, they've got the authority to issue orders, cost orders. The first question, when parties agree to take their dispute, whatever dispute, when they agree to take a dispute to arbitration, that normally is a term of the contract that the parties entered into. If it's an employment contract, it's an employment contract. If it's a contract of sale or lease or whatever, then it's that contract. And by agreeing to go the arbitration route, they then, in terms of the Arbitration Act, they then need to understand that the arbitration award is final. Once that agreement is in place, the arbitration award is usually a final award. I'm not aware of any appeal that can be, because this manner of resolution of a dispute between us is something that we as the parties agreed to respect, and even the choosing of the arbitrator is usually also provided for in the contracts that the parties have concluded. Okay, Mapula, I hope you can now speak. It looks like Mapula is still struggling to speak. But then I see my screen tells me and 8 others. Zukiso, can you see the 8 others? I don't want to move on only to find that there are people that have got questions.
There's Judith.
Hi, Judge.
I can only
Good
see.
evening, Judge. I've got a question.
I can only see Msizi and Judith Mutati. But the first one was Msizi.
Sorry,
Yes.
sorry, my lady. On first you have Musizi, then you have Bilal. On number 2, then on number 3 you have Judith. Then number 4 you have
wait a minute.
Lipeta. Then number 5 you have Shalima Lulega. Number 6 you have Cora van der Merwe. Number 7 you have Rinelwe, and then number 8 you have Mapula.
Okay, I hope everybody listened to their numbers, because I didn't keep that. I hope everybody knows now when to speak. Number 1, please go ahead.
Good evening, Judge. I've got a question here based on your presentation. When I look at your presentation and what is given here in my study guide, I don't think that it's I don't find it issues that talk about CCMA. Is it the stuff that you're presenting now? Are we going to be touching on the stuff on the content of your presentation because it's not aligned to what is in my study guide? Thank you.
Okay, sorry, your name is?
My name is Msizi.
Msizi. Msizi. The presentation is about alternative dispute resolution. Now, alternative dispute resolution is exactly what it says. It's the resolution of disputes outside the usual court processes. Now, the CCMA is one of those processes that are intended to resolve disputes without the parties going to court. So you will see it's not just the CCMA. There are others that I have referred to. They are all alternative dispute resolution mechanisms. Are we together? Do you understand what I'm saying?
Yes, I do, sir.
Okay.
But the question that I'm raising, sir, is that maybe the stuff that is in your the one that is in your presentation and what is in my study guide is not the same. Is it why the stuff that is in your presentation is not here? In the study guide, because I think at the end of the day, are we going to be tested on the stuff that is on the study guide? Is it the content that is given now on your presentation that is going to be part of our assessment, or the content of the study guide is going to be part of the assessment?
But Msizi, in the study guide, you've got dispute resolution. You've got what the study guide discusses are all the alternatives to dispute resolution. Alternative dispute resolution mechanisms. And those mechanisms are exactly what we're talking about: negotiation, mediation, arbitration, conciliation, and litigation is the part of dispute resolution that all of us are not keen to go that route because of the amount of time that it takes and the amount of fees that it takes. So when the study guide says alternative dispute resolution, it is looking for you to get a presentation on the various alternative dispute resolution mechanisms. I hope you're hearing what I'm saying. What you will do, you will read your study guide, but again, the study guide is talking about is telling you about a very, for instance, it's got role plays, right? It's got role plays, and those role plays, for you to be able to answer, because at the end of the role play, then you are asked to somewhere it will say mediate between the two parties. You will need this information, and you need information from a practical perspective. That is my take of what the study guide has and of what is expected of this session. For instance, if you go to arbitration, you will see that what it says. It says, what is arbitration? The characteristics of an arbitration, the arbitration process. I've just spoken through all of those questions with you.
Judge, if I may interject, just because there are two parts to the study guide. There's two separate attachments. The one just gives the role plays, like you said, and the other one just gives you an idea of what arbitration is and what the different processes are. And this year in the labor courts is just one route of arbitration that involves a relationship between an employer and an employee or former employee, but there can be other forms of arbitration.
And we're going to them. You will see that I've spoken in the slides. I've spoken about alternative dispute resolution at SARS. I've spoken about alternative dispute resolution in the financial services area. I've kind of picked on those that are very much alive, and those that a lot of people would like to know. If I want to lodge a dispute resolution with SARS, what do I need to do? You will see as we go along, because this is the first one. This is the first alternative dispute resolution mechanism, the one that I'm discussing with you now, which is in the labor space. For instance, you see that as up top there in the slide, the heading reads labor.
My lady, I think there is need for us to understand that we're in a practical vocational training, and my lady is within her rights not to follow the guide or not to follow the slides, because you are teaching us about the things that are practical. We've done 4 years of LLB or whatever training that we needed to do to get to this point. And this point, we learn to become lawyers and not people that are filled with legal knowledge. If people did not go through that training in their LLBs undergraduate, then perhaps they need to go back and collect their school fees. So do as you please
Very
and
much
as you
for that,
see.
but this is not
based-
necessary. This is not necessary. Can you allow the class to continue, please? Honestly.
Okay, Renee.
Good evening, my lady. My question is in regards to the legal representation that's not automatic. So I just want to understand as to what matters do not allow automatic legal rep and what are the reasons behind that?
Well, at the CCMA, legal representation is specifically provided for. If you have a matter that you want to take to the CCMA, excuse me, the rules of the CCMA actually say that you are entitled to have legal representation. Where legal representation is not automatic, it is in certain areas of employment. There are certain employers where they will say, if you are going to have a disciplinary hearing, we are not going to allow you to have legal representation. You will represent yourself, or you will be represented by another staff member or a union member, or what do you call them? A shop steward that is available in the institution, because institutions that are unionized, they will have shop stewards, and shop stewards do fulfill the role of representing employees when they are taken through a disciplinary process. That's where legal representation is not automatic. You might find that you are in an employment environment where legal representation is not automatic in a disciplinary hearing. Sometimes you actually have to ask for it, or argue for it, or even when you've argued, if the employer says this is an internal process, we are not going to allow legal representation, then that's it. That becomes final. All right.
Thank you, my lady. Understood.
Okay. Can we proceed now? Okay, I'm going to go back to my slides. I was on the Teams page. Okay, there you go, the ADR process at SARS. Here, we're talking, for instance, income tax, VAT, customs, all the taxes that SARS collects. You have received an assessment. Isn't it? We all are required to submit our tax returns. We all are required to submit our VAT returns. Those of us that are traders have got customs duties and excise to pay. And at any point where one is unhappy with the assessment or with the duty that SARS has charged me, or with the VAT that SARS say I owe, you are entitled to lodge an objection. Lodging an objection, what it means is that you are saying, SARS, you are incorrect. And they will ask you for grounds. What are your grounds for saying I'm incorrect? SARS may be incorrect because in their assessment, they did not take account of the fact that we're now working from home, and therefore we have charges that relate to home offices. We have charges that we would want to claim in our tax returns. We would want to claim costs that go purely because that we pay purely because we're working from home. Or SARS may have charged you interest unfairly, or there's various sections in the Income Tax Act that deal with interest. Or SARS may have levied penalties on you when you actually put in your tax return on time. You may have any number of reasons why you are objecting, and your objection must have those grounds that tell SARS why you believe SARS is incorrect. SARS will consider the objection, and having considered the objection, they will give you a decision. The decision may go against you entirely, or it may go against you, partly against you and partly in your favor. And to the extent that it has gone against you, and you still disagree, you are entitled to appeal against that objection. Once you appeal against an objection, then SARS sits and starts a process that is called an assessment of whether this is an appeal that must go to the Alternative Dispute Resolution Forum, or must it go to the tax board? The tax board is really, if I can make a comparison, is no different to a commissioner-chaired session at the CCMA, because the tax board is chaired by one person, the chairperson. The two parties, SARS and the taxpayer, will go to the tax board, and the taxpayer will tell the tax board why they believe that SARS is incorrect. SARS was incorrect to issue me this assessment. SARS, I appealed against the assessment. I objected against the assessment. SARS had an opportunity to consider my objection. SARS still came out with an incorrect assessment. I've now appealed, and the tax board must hear me. Or the matter may go to the Alternative Dispute Resolution Forum. And the Alternative Dispute Resolution Forum is a forum where a lot of the high ticket cases go. When I say high ticket, I mean high amounts, and where there is quite a lot of law that must be looked into, and where there's quite a number of documents that need to be perused, because the Alternative Dispute Resolution Forum, there's actually even a department at SARS, which is called the Alternative Dispute Resolution Department, which department has got staff that consider all these matters that come before it that have been referred to the ADR process. Now, excuse me, I hope it's now clear that what I am doing here is to expose you all to the various alternative dispute resolution processes in the country, in the various industries. We started with labor. We're now at SARS, at the tax level. So you will see that in the notes, in the slides that is before you, that I have said, I've put there, it all starts with the assessment issued following the submission of a tax return. If it's not a tax return, it will be a charge a charge that is imposed to a trader. A taxpayer who doesn't agree with the tax charge is entitled to lodge an objection, which will be considered and a decision will be issued. If the taxpayer is still not satisfied, the taxpayer is entitled to an appeal against the disallowance of the objection. We call it a disallowance of objection where SARS disagrees with you. In a notice of appeal, the taxpayer is entitled to select the ADR process, and upon consideration, this process may be found to be unsuitable, upon which the taxpayer's appeal will be referred to the tax board, which is like a mini tax court. We all know that there is a tax court, just like there is a civil court. There is also a court which exclusively considers tax matters, and that court is called a tax court. And these alternative dispute resolution mechanisms, they make life a bit easier, and they give decisions a bit earlier and speedier than you will get, for instance, if you take your matter straight to the tax court. Because if you take it to the tax court, then it means you're going to launch an application, and we all know what route an application will take. It's going to be subject to the rules of court that are in Erasmus. You all know the uniform rules of court that are contained in that big book called Erasmus. I think it's got about 3 or 4 volumes. And those processes, they are subject to certain timelines, and they're also subject to quite a lot of formalities that are not necessarily applicable in the alternative dispute resolution mechanisms. If found suitable, I'm now back in the slide. If found suitable for consideration within the ADR process, the appeal will be further considered and a decision or settlement will be issued. It is only after the taxpayer has failed to put a supportable case at objection at ADR tax board level that the tax dispute will go to the tax court. The processes are fairly quick given SARS's mandate to collect tax. One other thing that I have not mentioned is that these alternative dispute resolution mechanisms, they are also confidential in the sense that if SARS, for instance, decides to settle your matter with you at ADR level, at alternative dispute resolution level, that settlement is confidential. It is not something that is put out into the open. It is not reported upon. It doesn't become public. It is confidential between yourself and SARS. The same thing I was saying earlier on with respect to hearings at the CCMA. The hearings at the CCMA, there is no public. There are no public attendances. It's only the complainant, the employee complainant, or the employer. So because sometimes the complainant is the employer, and the employee and the representatives of the two parties being either a member of a union or a member of an employer organization. So the same principle applies here, because we're talking about alternative dispute resolution. In alternative dispute resolution, you expect that kind of pretty much like even in arbitration. The arbitration ruling or awards, let me say, the arbitration awards are normally confidential. They are not for public consumption. Either I proceed to the next slide, or I entertain questions if there are any. Let me go to the screen. I don't see any hands. Oh, here's a hand. Karabo.
Thank you, Judge. Just a quick one. You indicated that if we need a break, we must tell you. I thought yesterday's session was very long, and I wanted to find out maybe if it's possible to take a break from 22:30 to 22, 10 minutes, just to refresh our minds. I don't know if the class would allow. Just a thought. Thank you, ma'am.
Yeah,
Okay.
yeah.
There's a proposal for a break, 10-minute break.
Yes, please.
Okay, let's break for 10 minutes. We'll be back at 22. It's almost
Yes, please.
Thank you.
Thank you, ma'am.
Amanda, your hand is up. Do you want to object to the break? No. Unless somebody wants to say something, please, let's not have a traffic of hands. Okay, I will see you at 22. All right, it's 22:07 on the dot, 1840. I hope everybody is back from the break. Was there a hand just now? I thought I saw a hand, but it disappeared before I could see the name. If there's somebody who wants to say anything, please feel free so that we can start the next section. Bila? Bila, is that a hand or not a hand? All right, I'm going to start. We kind of just finished the ADR process at SARS. And I had invited questions, but if there are none, let us continue. I'm unfortunately not on the Teams screen now. I'm in the presentation screen, so I can't see hands. If there's a hand that if there's somebody that wants to say something, please feel free to raise your voice. Otherwise,
Good evening, Judge.
Evening.
There was a proposal in the chat that how about you take questions at the end of your presentation, that as you speak, we just note down our questions.
Okay, I'm very flexible. The only reason I thought to take questions as we go along is the fact that we're discussing issues from different industries and different areas. But I'm easy. I'm very easy. We can deal with questions at the end, if that is the preference. All right. In the next slide, please go with me to the slide that is headed ADR process in the financial services industry. In other words, the alternative dispute resolution processes that are operative in the financial services industry. There are some pieces of legislation that are applicable in the financial services industry. Some of you may have heard of the concept of Twin Peaks that has swept through the financial services industry, starting from, I think, roughly 2017. I think the white paper came out in 2014, and in 2017 there was a first draft of what is now called the Financial Sector Regulation Act. In the financial services industry, there's all these various applicable pieces of legislation. There's the Financial Sector Regulation Act, which I will explain. The Financial Advisory and Intermediary Services Act, which is commonly called the FICE Act. There's the Pension Funds Act. There's the Financial Markets Act. There's the Collective Investment Schemes Act. I have not put all of them. I have just put those that are very much in use, and those that are mostly always referred to. Like it says in the slide, these are some but not all pieces of legislation that are operative in the financial services industry. The industry is accordingly highly regulated because of the many, if you can look at all these financial, all these pieces of legislation, it is highly regulated, and it is therefore also highly litigious. Anywhere where you see a regulation, you can be sure there's going to be quite a lot of litigation, because there's always disagreements between the regulator and the regulated. The alternative dispute resolution process in this industry has been set up via a couple of ways. The first one is the Office of the Ombudsman for Financial Services Providers. And then the second one is the voluntary ombud schemes, two of which are the long-term and short-term insurance ombud schemes. There's the pension funds adjudicator. You remember I mentioned the pension funds adjudicator earlier on when we were talking about, when we were still dealing with labor. Somebody asked about benefits. If you have a complaint about your benefits and you're no longer in the employ of the employer, can you still go back and raise your issues? And the answer was yes. Yes.
I am sorry to intrude your class, but I cannot see the presentation of the slides, and I am just asking that, is it only me who cannot see them?
The presentation is not visible to you, to all of you, but the coordinator sent all of you an email with the slides.
Okay, thank you. Thank you.
So if you can just check your emails, you will see an email from the coordinator where the slides are attached.
All right, thank you so much.
Now, if you go to the slide that we're on now, is a slide that is headed the ADR process in the financial services industry. I think it's about the fourth or fifth slide or so.
Seventh slide.
Seventh. Oh, okay. All right. I mentioned the pension funds adjudicator earlier on, and then there's also the Financial Services Tribunal. I would like to take you through the process of Twin Peaks. Back before Twin Peaks came about, Twin Peaks, by the way, means there's two peaks, there's two regulators, and they're called peaks. So it's called a Twin Peaks regulatory regime. Before Twin Peaks came about, the financial services industry was regulated per sector. When I say per sector, for instance, let's look at the financial markets, the JSE and all the other market players out there. Those had their own statute. The FICE Act was responsible for all the services industries, and it was really, the FICE Act it really regulates the advice that is given to consumers by financial services providers. There's lots of these financial services providers. The insurance companies, for instance, are financial services providers. The banks are financial services providers. And there's lots of financial services providers. Now, when they give advice, the advice that they give, how they give that advice, they are the regulatory statute that deals with how they give you that advice and what kind of advice they give you and how they make sure that the advice they are giving you is advice that is relevant for your purposes and for your needs. Is the statute that looks after all of that is the Financial Advisory and Intermediary Services Act. Then you have the Pension Funds Act. The Pension Funds Act speaks for itself. It regulates how pensions are calculated by the various employers, people's pensions, how they are paid, how the various pension funds put together all of what is called pension benefits for people. Remember, I was saying earlier again, the benefits that somebody may be complaining about may be pension benefits, and if they are pension benefits, then the CCMA will refer that person to the pension funds adjudicator. There's a Financial Markets Act. The Financial Markets Act, I've already alluded to it. It deals with the financial markets out there. There's a number of them nowadays. There's ZAX, there's the Johannesburg Stock Exchange, there's another, I think there's 4, if I'm not mistaken. There's either 3 or 4 exchanges that are active currently now. And they are all regulated by the Financial Markets Act. We've got the Collective Investment Schemes Act. Collective investment schemes are what used to be called unit trusts. There's an act that regulates all of that. And as I'm speaking, you can hear that each statute is dealing with a particular sector. Now, Twin Peaks came along. And Twin Peaks, what Twin Peaks is saying is that we're not going to regulate per sector. We are going to regulate conduct across the sectors. We're going to regulate how you conduct yourselves, how you treat your consumers, your customers, your clients, how you treat them. Within market conduct, there's also something called treating customers fairly. And that concept is a concept that is part of the requirement to treat to regulate market conduct across the sectors. Then the second peak is a prudential peak. That peak, so before I go to the second peak, the first peak, the regulator in the first peak is the Financial Sector Conduct Authority. Some of you may have heard of it. The Financial Sector Conduct Authority, its offices are in
Lane.
Please. If you're in Menlyn, you are looking across Sector Conduct Authority. That's the peak that All right, prudential issues are issues that are to do with money. And financial services providers that will be regulated prudentially, for instance, are the insurance companies. All the various financial services providers that make certain promises, to the effect that at a certain point in the life of this financial product that we are selling to you, you will get a sum of money of so much. That particular financial services provider needs to be regulated prudentially because there is a need to ensure that those promises can be kept. The particular financial services provider will be able to make good on the promises that they make to people. The banks, for instance, are also prudentially regulated. This,
Sorry, George.
Financial services. Interruption. Yes.
You're speaking to Leslie. I lost you now for the second time. I'm not sure if the rest of the class did as well. Is it possible for you to repeat after you ended with the first leg of Twin Peaks?
Yes, please.
We lost you a little from them, Judge. Pardon.
You're saying I must repeat what I said after the first.
After you finish the first leg of Twin Peaks, please.
Yes,
okay,
please.
Okay.
Thank you.
The second peak is the Prudential Authority. Okay. And that peak is the peak that regulates all financial services providers who in their business, they promise their clients and their customers a certain amount of money at a certain particular given point in the life of the product that they are selling. Let's make an example with an insurance company. An insurance company will say, pay so much, pay a premium of so much for insuring your car. If your car gets stolen, we will pay you the market value amount of your car. If your car gets involved in an accident, we will fix your car. We will repair your car. We'll pay the cost of fixing your car. There are a number of such financial services providers whose business is such that they promise a certain an amount or a payment of an amount of money, and the Prudential Authority, the business of the Prudential Authority, is to regulate and make sure that those particular financial services providers can make good their promises when the time comes, and how that they obviously watch their capital requirements. The capital requirements, the capital they watch how they
sorry, Judge.
How they even market it. Yes.
Can I suggest that you turn off your camera? Maybe the quality of the meeting will improve.
Is my camera on? Oh, yeah. I never liked that. Okay. Okay. Thank you. Thank you. I've turned off my camera.
sounds much better.
Oh, okay, good. So even the way that these products are marketed is very much under the spotlight with respect to the Prudential Authority. The Prudential Authority resides within the Reserve Bank. It is a part of the Reserve Bank. The Chief Executive Officer of the Prudential Authority is one of the deputy governors of the Reserve Bank. All right, and and the law that the Prudential Authority uses to regulate the financial services providers that are prudential in nature, whose services are prudential in nature. The law is in the Financial Sector Conduct Authority, sorry, in the Financial Sector Regulation Act. So is the law that governs market conduct is also in the Financial Sector Regulation Act. This act, it came out at the beginning of 2018. I think it became effective towards the end of March in 2018. So this is how the Financial Sector Conduct Authority and the Prudential Authority were born. And all the other various acts, they are still operative to the extent that this act has not been to the extent that the Financial Sector Regulation Act has not been able to cover certain aspects. Can I please ask that you mute, please?
And then they will stop selling like that.
Please mute yourselves so that I can speak. So both these two peaks, their functions and their creation are contained in the Financial Sector Regulation Act. So you have what is called Twin Peaks regulation in the South African financial services industry. I hope there's a lot of detail to all of this, but it's not possible to cover all the detail because the intention here is to show the alternative dispute resolution process within the financial services industry. But I can't not at least give you some idea of the background, against which these alternative dispute resolution processes operate. For instance, now, if I come back now to the alternative dispute resolution processes, I'm going to mention to you the Office of the Ombudsman for Financial Services Providers. That is the office that regulates the advice that is given to financial services consumers. And that office, you will find that office also in Menlyn. Currently is, those of you that know Menlyn, opposite Menlyn Main, right next to the big Toyota service point there. There's a big Toyota there. Right next to that Toyota, there's a building there which houses the Ombudsman for Financial Services Providers. And the various voluntary ombud schemes, for instance, the long-term and short-term ombud schemes, which look after the conduct of the of the insurance industry. Those are seated in Cape Town. They are situated in Cape Town, and but they are, all these ombuds are within reach, because they are all all have various, and in their websites they've got documents, they've got all sorts of documents that are used in the instance where somebody wants to access them or wants to lodge a complaint. The pension funds adjudicator is in the same campus as the financial sector regulation. So sorry, the Financial Sector Conduct Authority is in the same campus in there. At that campus is called Riverwalk Office Park. As I said, it is opposite Menlyn. It is just across the freeway. The Financial Services Tribunal now, if, excuse me, if I, as a financial services consumer, I go to the, I was dealing with a financial services provider, and they gave me advice which I think they did not think properly about. They did not look into my circumstances. They did not do a due diligence of my financial position. They did not worry about anything that actually needs to be looked at with respect to the advice that I need to be given. I then go to the Ombud for financial services providers to lodge a complaint. The financial services, the Ombud for financial services provider looks at my complaint, considers my complaint, goes through all the processes that must be followed in considering the complaint, including talking to the financial services providers that I'm complaining about, including trying to mediate between the two of us to see whether there is any scope for mediation, there is any scope to get the matter settled, or to get not settled, but for the financial services provider to understand my complaint and make good financially my loss, or in any way that I can be satisfied. If the Ombud is unable to reach that, then the Ombud is going to make is going to make a determination. The determinations, unlike settlements, the determinations are publicized. If you go to the FICE Ombud website, you will see there an icon for determinations. And those are all determinations that have been written, that have been put together and written against particular financial services providers for all sorts of financial services providers' misdoings. Now, if the financial services provider that I took to the Ombud, and the Ombud made a determination against that particular financial services provider, if that financial services provider is unhappy with this determination, that financial services provider is entitled to apply for a reconsideration of the determination of the financial services Ombud, of the Ombud for financial services, by the Financial Services Tribunal. I know it sounds a bit of a tongue twister, but I hope you have understood. First, a financial services provider provides me advice. 6 years later, 5 months later, 10 years later, however much time elapses, and I realized that the advice that I was given was wrong. It was never supposed to have been given to me. there is also a code of conduct that governs how the financial services providers should render their advice to financial services consumers. And that code is very, very clear on certain things, including what I talked about earlier, which is due diligence. If I'm unhappy, I go to the ombud.
This will stack up well against other Fluttermates, while also resisting bug and fighting attacks that previously would have been super effective. So I have the strongest Pokemon on the format, and the Pokemon that I think will allow me to handle one of the more so threatening teams. Now we need Pokemon.
Peterson.
The ombud issues a determination, and in the determination, if the ombud is entitled to order a payment of a certain amount, depending on what it is that I'm claiming. If I'm claiming a certain amount, the ombud agrees with me, then the ombud will order the payment of that amount. And once the ombud also in law is entitled to go to court to get the determination noted by the clerk of the court, the magistrate's court, and once it is noted by the clerk of the court, it becomes an order of court, which means that the financial services consumer can actually execute against that particular order, can execute against the financial services provider. If the financial services provider is unhappy, then they go to the financial services tribunal, as you can see in that third paragraph in the slide. The last sentence I say in that paragraph is, this is over and above the various dispute resolution offices in the financial services providers' offices themselves. You will find that if you go to Standard Bank, they've got an office where they say it is an office where disputes are settled. Where if you are unhappy, if you have been treated badly by an employee there, you go and complain. You go and put a complaint in that office. It is within Standard Bank. It is within FNB. It was within a particular insurance company. That office. Those offices, so they sometimes work, sometimes not. But they are there, and they are also dispute resolution, alternative dispute resolution, in a manner that says, if we have done you wrong, we would like to know, and we would like to get an opportunity to apologize or to make good in whatever way we can. I did say that the Twin Peaks legislation is not over yet. It's still in the process of construction, development, continued development. For instance, currently there's the Conduct of Financial Institutions Bill, which is still under development and under discussion. And that piece of legislation is the one that's going to deal with the conduct of all the financial services providers across the board. Remember, I said the Market Conduct PIC, the Financial Sector Conduct Authority, is mandated to regulate the conduct of financial services providers across the board. Now, that piece of legislation will deal with the conduct of all financial institutions, and is still currently a bill, and is still under discussion by Parliament, National Treasury, the Financial Sector Conduct Authority, and the industry, and all other interested parties. The government, interestingly enough, the Government Employees Pension Fund Also recently, I think about 2 years ago, 2 or 3 years ago, they established their own ombud as a voluntary complaints handling mechanism, which was established by the board of the fund, of the Government Employees Pension Fund. All of the above ombud schemes are available online and are practically within reach, either electronically, walking in, or writing to them. Those are the practicalities, the practical aspects and the practicalities of the ADR process in the financial services industry. Oh, by the way, we agreed that questions will be entertained at the end. Okay. Then I think let's go to, unless somebody wants to say something other than a question, let's move on to the next slide. And in the next slide, I'm going to start on a course of something like what, 4 or 5 slides, which discuss Rule 41, capital A, of the rules of court, the Uniform Rules of Court. This rule was put together for purposes of putting a process of mediation within the litigation processes. In other words, to cut down on a lot of the litigation that takes place, and to also try and catch up with a lot of the backlog in terms of the litigation that the courts in South Africa are seized with. The South African Rules Board got together and decided, let there be in the rules, in the Uniform Rules of Court, let there be a rule which entitles litigants to take their matters into mediation if they so please. Now, I've put in there, excuse me, I've put in there all the various steps that must be taken to ensure that a particular litigant or particular litigants agree that we want our matter to go into mediation. And that on its own, the fact that even our rules of court, they provide an alternative to litigation. It shows the maturity of the alternative dispute resolution mechanisms in South Africa. Because what it does is that it says it recognizes alternative dispute resolution. The rule came into effect on the 9th of March 2020, and it is headed, if you go into the rules, Rule 41, capital A is headed mediation as a dispute resolution mechanism. And the rule itself defines mediation, and it defines mediation as a voluntary process which is entered into by agreement between parties to a dispute, in which an impartial or an independent person who is the mediator assists the parties to resolve the dispute between them, to explore areas of compromise, to generate options to resolve the dispute, to clarify priorities by facilitating discussions between the parties and assisting them in their negotiations to resolve the dispute. The last part is in the next slide. The mediation is accessed there's a process for accessing the mediation. A plaintiff or an applicant, together with the summons or notice of motion, will serve on each defendant or respondent a notice indicating agreement or opposition to referral to mediation. In other words, even as you prepare your notice of motion and your affidavit, or even as you prepare your summons and your particulars of claim, you put also a notice that indicates that I am in opposition to referral to mediation, or I am in agreement to referral to mediation. I will agree to referral to mediation. By so doing, you're giving the other side, you're prompting the other side, which is either the defendant or the respondent, to, when they file their plea, or actually when they file their notice of intention to oppose, before filing their plea and before filing their answering affidavit, if it's a respondent, they then issue a notice, serve on the applicant or the plaintiff, a notice indicating whether they also agree or also oppose referral of dispute to mediation. I hope that has been clear. Now, the notices are required to be substantially in accordance with Form 27 of the first schedule. Form 27 is in the Uniform Rules of Court, in other words, the book by Erasmus. And those of you who have your Erasmus with you will go to page D1-832 capital A, and that's where you'll find Form 27 of the first schedule. And those notices, the notice shall clearly, it must clearly and concisely indicate reasons for the party that believes that the dispute is or is not capable of being mediated. If I put it and I say this dispute is not capable of being mediated, I need to put clear and concise reasons. If I put, I come back as a respondent or defendant, I say this dispute is capable of being mediated. Once again, I will put reasons why I say that. Rule 3 says the parties may, at any stage before judgment, in spite of what Rule 2 says. Rule 2, you'll recall, Rule 2 says you've got to file your notice before the plea or before the answering affidavit. That's what Rule 2 says. But Rule 3 says, even though Rule 2 says what it says, there's nothing stopping the parties at any stage before judgment is handed down to agree to refer to a dispute to mediation, provided that it is a trial or application that has already commenced. Parties shall obtain leave of the court for referral. What that sentence says is that should the trial have already commenced by the time you decide that you would like to go the mediation route, then you must approach the court and ask for leave of the court in order to refer your matter to mediation. Next slide. The judge or the case management judge may at any stage before judgment direct the parties to consider referral of dispute to mediation, and the parties may so refer the dispute. It depends if the judge or the case management judge can see that this particular dispute has got certain features that can be mediated, that can be agreed upon, that do not need to await and to go through all the rigorous processes that are involved in litigation, then the judge may direct the parties to consider referral of dispute to mediation. Mark my words, the judge does not force the parties to go to mediation, but the judge will ask the parties to consider the referral of a dispute to mediation. And if a dispute is referred to mediation, parties are entitled to deliver a joint signed minute which records their election to refer the dispute to mediation. This is now a document which shows that both parties have agreed to refer the dispute to mediation. And the parties shall also, prior to commencement of the mediation proceedings, enter into an agreement to mediate. Over and above the joint minutes, they will enter into the joint minute. I don't think is a long document, but the agreement to mediate may very well have some clauses which show why the parties believe that their dispute is capable of mediation. The time limits that are prescribed by the rules for the delivery of pleadings and the notices and the filing of affidavits or taking of any of the steps that are taken in litigation, they get suspended once parties express an intention to go the mediation route. So nobody can say you are late with your answering affidavit. No one can say you are late with your replying affidavit. No one can say you are late with your plea or your discovery notices. No one can say you are late with anything, because right now we have suspended the litigation. We are going the mediation route. Let's go to the next slide. And the process of mediation is required to be concluded within 30 days from the date of signature of the minute that was signed. You remember I referred to a joint minute that is signed by the parties. Provided that a judge may, on good cause shown by the parties, extend such time period to accommodate the completion of mediation. If a judge can see that these parties, they are genuinely wanting to mediate and they want to finalize their dispute via the mediation, and they just need time, they just need the benefit of time, and then the judge will be satisfied that there's good cause shown to extend the time, the 30-day period. There will be instances where there are multiple parties, right? And some of whom will agree to mediation and others will not agree to mediation. But the rule says those who agree to mediation, they must be given the opportunity to proceed to mediation, notwithstanding the other party's refusal to mediate. The other party's refusal to mediate will in all probability be decided in accordance with the result of the mediation. The result of the mediation may play a part in the dispute that the other parties are refusing to take to mediation. And the time limits that were referred in the fourth clause, they shall be suspended until the mediation by every party who is elected to mediate has been concluded. And then once again, there is a provision that provided that any party to the proceedings who considered that the suspension of time limits is being abused, which happens a lot in litigation processes, and it will happen even in alternative dispute resolution processes, the abuse of process. The abuse of the suspension of the time limits may very well be an issue. And if the judge is approached by any party who believes that there's that kind of abuse, then the judge may very well entertain an application to uplift the suspension of the time limits. Shall we move on? In any matter where there are multiple issues, remember I've already spoken about multiple parties. There may be multiple parties and there may be multiple issues. The parties may agree that some of the issues be referred to mediation, and that the issues remaining in dispute may proceed to litigation. Parties may very well, and it's a sensible route to take in certain instances, not to waste the court's time, not to waste money, because there's a lot of money to be paid by parties as counsel and attorneys appear on their behalf in court in litigation proceedings. If you can narrow down the issues that must go to litigation, and then you take the other issues to mediation, then there's everybody wins. You know, the system, the administration of justice system wins, and the time the court has to consider other matters saved, and also the parties to the litigation or to the disputes, they save money that is in short supply, to say the least. And then Rule 6 says, except as provided by law or discoverable in terms of the rules or agreed to between the parties, all communications and disclosures, whether oral or written, that are made at mediation proceedings are confidential and they constitute inadmissible evidence. In other words, you can't come back from mediation and come, and come to litigation and say, but you said at the mediation proceedings, you said A, and whatever that other party may have said would be against them, would operate against their case in the litigation. That is not allowed. Everything and anything that is said in the mediation proceedings stays there. It is confidential. It constitutes inadmissible evidence in the litigation proceedings. Rule number 7. Upon conclusion of mediation, parties who engaged in the mediation shall inform the registrar and all the other parties by notice that mediation has been completed. And even parties that have failed to engage in mediation, even parties that have failed to deliver the notice referred to in the above paragraph, the suspension of the time limits referred to in sub-rule 4 shall lapse unless a judge has extended the time limit. So if you come back from a mediation process and your 30 days is up and you have completed the mediation, you can't come back and just keep quiet. If you keep quiet, the system is going to catch up with you, because the system will record that you are supposed to be done with the mediation, and the suspension of the time limits that you had been granted will lapse unless a judge has extended the time limit. You recall that we talked about a judge extending the time limit to give parties time to finalize their mediation process. Mediation again shall be deemed to be complete within 30 days from the date of signature of the joint minute, from which date the suspension of the time limits prescribed for the delivery of pleadings and notices and filing of affidavits or the taking of any steps shall lapse, provided again where mediation is completed before the period of 30 days, the parties who engage in mediation must deliver a notice contemplated in sub-rule 7 that indicates that mediation is completed. So the fact that parties are given 30 days doesn't mean that they will stay for 30 days in spite of finishing mediation, concluding mediation within 15 days. If they conclude mediation within 15 days, then they need to come back, and advise that they've concluded the mediation, so that the suspension of the time limits can be uplifted. Rule 9.8b provides that the parties who engaged in mediation and the mediator who conducted the mediation shall, within 5 days of the conclusion of the mediation, issue a joint minute which indicates whether full or partial settlement was reached or whether the mediation was not successful, and the issues upon which agreement was reached and which do not require hearing by the court, so that the court knows exactly what are the narrow issues that are before it. Paragraph C provides that it shall be the joint responsibility of the parties that were engaged in mediation to file with the registrar the minute that is referred to above. The minute that says we are done with mediation. This is how it went. It must be done within 5 days of the conclusion of the mediation. No offer or tender made without prejudice in terms of this sub-rule shall be disclosed to the court at any time before judgment has been given. An offer that has been done, that has been made at the mediation process will not be, obviously it is made without prejudice. It can't be disclosed to the court before judgment has been given, because it is not supposed, the mediation is not supposed to compromise or to disadvantage the parties. The judgment of the court can be given on the issues that were litigated upon, and then the parties will then say that there was an offer. We have an offer, and the offer is as follows. Where the parties have reached settlement at mediation proceedings, the provision of Rule 41 shall apply mutatis mutandis. Rule 41 is again a rule that seeks to deal with litigation proceedings in as fast a manner as possible. Where are we? We are at the end. Rule 9 of Rule 41, capital A, sub-rule 9 is, it says, unless the parties agree otherwise, the liability for the fees of a mediator shall be borne equally by the parties that participated in the mediation. And where an order for the course of action or application is considered, court may have regard to the notices referred to in sub-rule 2. Those notices, remember, those are the notices where the parties were indicating whether they want to go the mediation route or not. So now when the costs are considered, they will be considered with due regard and due consideration to those notices. Because, look, I mean, if a party says, I had recommended to all of us that let's go the mediation route, and then the matter goes and takes forever in litigation. The part that did not go the mediation route takes forever in litigation, and the part that went into mediation takes a reasonable amount of time. The cost of action or application that went into the litigation are definitely going to be considered with reference to the parties that had an appetite for mediation, which mediation proved to be shorter and faster and quicker to resolve. This rule 41A, I deemed it expedient to discuss it with you because it is a rule that has been inserted into the rules of court, into the processes and procedures of court. And it is a rule that clearly recognizes alternative dispute resolution mechanisms. And it is a rule that has been made to say, even where parties do not have an alternative dispute resolution mechanism in their industry or in the industry in which their dispute lies, there is an opportunity within the rules of court for parties to utilize an alternative dispute resolution mechanism, which is what is encapsulated in Rule 41, capital A. That brings us sort of to the end of what I had prepared for purposes of dealing with alternative dispute resolution mechanisms. And I think this is the time for questions and any discussions that people need to have. I'm not in the, okay. Leslie Sampson. Somebody please keep.
Evening, Judge.
Good evening.
This is Leslie. Wonderful lecture, Judge. Honestly, one of the best we've had this far. I just have one clarifying question, please.
Yes.
If you would look at page 7 of the presentation, you elaborated on the ombuds, or is it those 5 pieces of legislation?
Sorry, what is the heading there?
On page 7 of the presentation, you elaborated on, if I'm correct, a specific ombud. Is it the ombud for financial services provider, or were you elaborating on the 5 pieces of legislation? I would just like to go back and make notes on it, please.
Okay. Would you like me to discuss? Papa.
Sorry, Judge.
Papa. Please, Papa, mute yourself. Leslie, would you
Yes,
like me to discuss the ombud for financial services providers?
Judge, I would just like to clarify what you were discussing. I couldn't make out a lot there.
Oh, okay. The heading there says ADR process in the financial services.
Foreign Judge, I'm so sorry.
The heading.
Yes.
There says the ADR process in the financial services industry.
Yes.
Right. Now that is intended to demonstrate the alternative dispute resolution processes
Yes.
that are applicable in the financial services industry.
Yes.
Now, in the financial services industry, we have just recently had a complete revamp of financial services in the way that it used to be. The industry used to be regulated per sector. When I say per sector, let's say insurance is a sector, for instance. Capital markets is the sector, right?
Yes.
So that whole industry used to be regulated per each sector, right?
Yes.
So sector would have its own act. Now, Twin Peaks came along. Twin Peaks said, no, we're not going to regulate per sector. We're going to regulate on the basis of two requirements: market conduct, how you conduct yourselves in the market, and how you conduct yourselves prudentially.
Yes.
Okay. Now, when the industry used to be regulated per sector, there were all those pieces of legislation. I only just quoted 5. There's more than 5, there's about 13 of them. The other ones that, some of the ones that I did not put in there, I did not put because they've already been repealed. Okay?
Yes.
And then the ones that I put in there are the ones that are very much in the eye, in the public eye. For instance, the Financial Sector Regulation Act is the act which created the 2 peaks. Remember, I talked about two peaks?
Yes, yes.
The market conduct peak and the prudential peak. So the Financial Sector Regulation Act is the one that created the 2 peaks.
All right.
So this piece of legislation is very, very topical. The Financial Advisory and Intermediary Services Act is still very actively out there because there's a lot of advice that is being given to people, to financial services consumers, which advice in a lot of instances is inappropriate. For instance, an old lady of 75 years old is advised to invest in a property building scheme, right?
Yes.
And the property building scheme will start making profits in another 10 years, in another 15 years, in another 20 years, right? Where will my aunt be, who's 75 years old? Where will she be by that time? And sometimes an old lady of that age is given advice which doesn't take care of the fact that in a very short space of time, she's going to sit down and not work and she's retired. She's going to retire. She's going to need a lot of money, and she's going to need a lot of money, but she's going to need the money coming to her in a manner that can sustain her life. And the advice doesn't take account of all those factors and issues.
Yes.
and important matters to a particular financial services consumer who needs to be given advice that will not just serve her now, but that will be good for her in the coming years, especially the pension years. So the Financial Advisory and Intermediary Services Act is very much topical for that reason, because it regulates that kind of advice. It looks at that kind of advice. The Pension Funds Act is topical for obvious reasons. I mean, everybody has got a pension. Okay, let me not say everybody has got a pension. Everybody that's employed by an employer who's registered their employers in a pension fund scheme. That's the best way in which people in South Africa save. The majority of people in South Africa save via their pensions. So the Pension Funds Act is a topical act. The Financial Markets Act is a topical act because that's where the trading of shares and all these financial instruments that you see being traded on the stock exchange, that's where they get traded. So the Financial Markets Act is a very topical piece of legislation. The Collective Investment Schemes Act is still quite topical because there's still quite a lot of people that have got that save via that method of saving. In other words, I don't have enough money to save a huge amount on a monthly basis. But if our little bits of cash is pulled together, there's 5 or 10 or 15 or 50 or 100 of us, our cash is pulled together and it goes and it gets invested in a really good investment scheme. We come out with very good profits, where on my own I would not have been able to invest in that particular product. Are you with me? You understand what I'm saying?
Yes, Judge.
So that Collective Investment Act is still also quite topical. So the please mute.
Pardon.
Now, the alternative dispute resolution mechanisms that I put under those 5 pieces of legislation are intended to show that for these industries, there are these alternative dispute resolution mechanisms that are in place. For instance, for the Financial Advisory Intermediary Services Act, there's the Ombud for financial services providers. There's the voluntary ombud schemes, which also participate in the financial services providers financial services products that are marketed to consumers. There's the pension funds adjudicator, which is an ombud that deals with complaints that come through from people dissatisfied with how their pensions have been dealt with. There's the Financial Services Tribunal, which is the tribunal which adjudicates any complaints between an alternative dispute resolution a structure like the pension funds adjudicator and a pension fund. If the pension funds adjudicator goes if the pension funds adjudicator gives an award that is against a particular pension fund to a particular individual, the pension fund will go to the Financial Services Tribunal to say, hey, this pension funds adjudicator has not complied with particular provisions of the Pension Funds Act. There are lots of provisions. The Pension Funds Act is fraught with a lot of provisions that a lot of employers and a lot of pension funds don't get right. It's the same thing with the others. So I was saying the last sentence that says the Twin Peaks legislation is still under continued development, and there are expected developments. And I made mention of the conduct of financial institutions bill, which is still being discussed, which is still under discussion. I hope I've clarified what you needed clarified, Leslie.
Yes, wonderful, Judge. I really appreciate it. It makes so much more sense. One last question: how would you like us to study this? Would you like us to be able to give a short description of these 5 relevant legislation pieces?
How would I like you to study?
Yes. These 5 legislation pieces, should we know where they fit in and have a description of them?
Well, I think it's a question of just understanding what they're about.
All right. All right. Thank you so much.
You're not really going to be
I don't
think they're going to be tested on what they do, on the nitty-gritties and the details of them. The very important thing here are the alternative dispute resolution mechanisms that are applicable in the financial services industry.
All right.
Yeah.
All right. Thank you so much, Judge.
It's a pleasure. I don't know who came after Leslie. Please, I rely on you guys to please just follow. You know who you put your hand up after. Yes. Who is that?
What is this dance move,
Ma'am, Cora
Judge.
van der Merwe is next.
Cora.
Ma'am, thank you for the opportunity. I had a question, but in the discussion that followed, you actually answered my question. Thank you very much.
Okay. Okay. I'm happy to hear that. Who followed Cora?
Ali Richard.
I gave her a $20 bill. For what? For anything. I don't care. Whatever it's for, but she can give me my money back if she ain't.
Ali Richard, you're next, and after that is Janus.
What kind of drugs do you want to buy? Rock.
Ale.
Gave her $20 back. $20. She gave me some plaster.
Somebody,
you
please.
$20 back. Because she didn't supply you.
Yeah, you can hear everything.
Ali seems to be watching something, man. If we could go to Janus.
Okay, please mute it. Who is this?
Mute yourself.
You go. This is my child.
Zukiswa, please mute Ali for us, and then we can go to Janus.
Okay, Janus.
Thank you very much, Judge. I just have a quick question regarding Rule 41A. I have noticed that in some cases, okay, good heavens. I have noticed that in some cases, the parties enter a notice of objection to Rule 41A. I'd just like to know that if a party serves and files an objection to 41A, does that mean that mediation proceedings cannot go forward throughout an entire case, or can it still be referred to mediation even though the objection is there?
Please, can I ask that somebody mutes themselves? Who is it? Can you see? Okay, thank you. Then,
Open your head. Kylie, be for real. Up in here.
This is really unkind. Can I ask somebody
Judge, it seems like Ria Betsu.
It's Riabetsu. Riabetsu, please mute yourself.
Thank you, Riabetsu. Janus, you will see that the mediation, the judge cannot force the parties to go to mediation. But there is somewhere, I think rule 7 or rule, but towards the end, the judge, having had an opportunity to see and hear the issues in the matter, the judge can actually ask the parties to reconsider, to consider if they don't want to go the mediation route. That's number one. Number two, a party who has refused, objected to mediation, they might object partly on a particular aspect of the matter, and not object on another aspect. So to the extent possible, parties who are able to say, I'm happy for this aspect to go into mediation. However, on this aspect, I would like to go the full course. I would like for this particular portion to be litigated on. So that's the second option that parties have. And also you recall that there are instances where there are also multiple issues and multiple parties. The fact that one party refuses mediation does not stop the other parties going into mediation if they so wish. But of course, you can't go into mediation all by yourself. The parties that go into mediation has got to be parties that are opposed. Because if you are the respondent, if you come from the respondent side, or if it's just the respondent, or it's just the applicant, or the plaintiff, or just the plaintiff, or just the defendant, then there's nothing to mediate. So the very important aspect to consider are the issues. Because the issues, this is why it is so important, for instance, to do what is called a decision of the issues that are not in dispute. In other words, the issues that are admitted by both parties. Ne? And then to then separate those from the issues that are in dispute. Because once you know which issues are in dispute, you then know, okay, there's 2 or 3 issues that are in dispute. And of the issues that are in dispute, you look at the issues that have been admitted and see whether of the issues that have been admitted, there isn't any portion or part of those that actually talks to the issues, to those issues that are still in dispute. I see. Yeah.
Thank you very much, Judge. So, for instance, a practical example would be, let's say, in an RAF matter where one needs to settle merit and quantum. The merits can be in dispute, but the quantum can, for example, be mediated.
Yes, exactly.
I see. Okay, thank you very much, Judge. I appreciate it. Thank you so much.
Okay, thank you.
Ma'am, Alice seems to be sleeping. Leslie already has been answered. Next is Tulufelo, followed by Jacob Modise.
Okay, Tulufelo.
Thank you, Judge. Judge, I wanted clarity on slide 12 on the multiple parties. Can you maybe give a practical scenario in that case? Maybe, a scenario on What kind of matter would that be where some refuse and then the mediation proceeds?
Some refuse and others agree. Is that where you are saying you're talking? Is that where we're saying maybe some parties that may refuse mediation and others
yes,
agree?
on Rule 5. Yes.
It's difficult to think offhand of a specific case, but you might find that you know, like parties may have sat in a meeting and they would have had discussions in a particular meeting, and you might find that of those parties that were sitting and discussing issues in a particular meeting, they will not have the same understanding of what came out of that particular meeting. And those that have got a different understanding from the others may very well say, I don't want to litigate over this, because in that meeting, this is what was said. And then the other ones that have got another understanding, they will say, no, that's not what was said. That's not what was said. What was said was this. And then those that say what was said is such that I can't go into mediation, then they will want to hear viva voce evidence in court and have a cross-examination, because they feel that they want to cross-examine the witnesses. Are you with me?
Yes, Judge, I am.
Yes, it will be an instance, for instance, where somebody strongly believes that if I can put that particular witness on the stand and extract evidence from them, I will be able to cross-examine that particular witness and break them down and come out with a different position from what the mediation process might unearth. The bottom line is that parties that don't want to go the mediation route are parties that believe that there's no middle ground here. It's either black or white. Whereas where parties believe that, hey, we had this, we had so and so say this, but then so and so turned around and said this, and you know, all those things that happen when people are involved, embroiled in a particular case that lends itself into a dispute, finally into a dispute.
Okay. Sorry, can I give an example? Can I assist with an example there?
Okay.
So recently in insurance, we had the issue of business interruption claims when it comes to COVID claims. So businesses were interrupted. We have a cover called business interruption in insurance, yes, whereby you are covered for anything that would have interrupted your business. Yes. So with COVID as a pandemic, the insurance industry was saying that it was not the intention of insurance to cover a pandemic. It's not insurable. But the insureds are saying, but it's not excluded in your policy wording. Your policy wording, as it is, it covers COVID as a pandemic. So that's a possible example whereby some insurers were offering I mean, payment of a million or whatever
Yes.
in mediation processes. So some policyholders did not agree to that, and yeah, so that's just an example of whereby some policyholders can agree to mediation or want to proceed or whatever.
It's a great example. It's a great example. Thank you very much for that. Thanks a
Thank you
lot.
so much for the clarity. Then, Judge, my last question on the processes of the CCMA on slide 5.
Mm-hmm.
The last bullet point says, after completion of process, commissioner issues an award within 14 days, and if any party does not comply with the award, same can be made with the labor court. So I know of someone who went through that whole same process, and what happened was after they implied, they issued a writ of execution with the sheriff.
Yes.
On the day the sheriff served that writ of execution, Judge, the employer Soma moved. So after getting the writ, obviously he was informed that he needs to comply. And what he did was he's changed offices. What other recourse does she have? Because now she went back to the CCMA to say, but now what's our way forward? And they're unable to assist her. Can she maybe try locate the employer herself and then go back to the sheriff or go back to the CCMA? Because she was unfairly dismissed during the shutdown Tembisa strike, whereas nobody was able to go anywhere, and then her employer dismissed her for not being at work for the 3 days of the strike.
And then when she, on the day that the sheriff was going to execute, the employer changed address.
Yes.
So
we don't know how he actually found out that the sheriff would be coming.
Yeah, then hey, that was in bad faith. That's an act in very, very bad faith. I would. You see, the thing is, some of these things, they happen to people, and the people get defeated because they don't have the means. Because under those circumstances, then you need tracers. You need people that can trace those people where they are, and we might even want to because that is not just in bad faith. It is also contemptuous because it seeks to defeat the effect of the judgment. It seeks to defeat the effect of the judgment, and if somebody like that were to be traced, I would, if I were that employee, I would also ask the court to seek the cost, to actually load put a cost order that punishes that person, a very punitive cost order that covers my costs for tracing them and covers my costs for having come to court. But the thing is, tracing them for purposes of executing on the writ is such that you don't have cause to go back to court unless you want to go back to court to seek a contempt order against them. If you want to go back to court to seeking a contempt order, then that's a different thing. But once you have traced them, and the sheriff can execute on the writ and take once the sheriff is able to execute on the writ, then that's the end of the initial proceedings. Are you with me?
Yes.
Yes, but as I say, you might wanna you might find that somebody wants to take them on from a contempt perspective, to say he or she they sought to frustrate the order of the court. They sought to render the order of the court what is called a brutum fulmen. In other words, it can't be, it couldn't be executed because they simply changed premises, which was in very bad faith, I would say.
Yeah, thank you so much, Judge, for the advice. I will guide them. I took note of everything that you just said now. Thank you.
A pleasure. Is there somebody else?
Yes, Judge. Yes, Jacob here. Thanks. Thanks for the opportunity to host us today. Judge, my question is based on the other industries. Like I think in our lecture this evening, in industries which were mentioned were industries like your labor and your financial and your insurance. But coming to the construction industry, there is this. Sorry, Judge.
I didn't mention the construction industry. I agree. It's just that again, like I was saying, there's quite a number of industries that have got alternative dispute resolution mechanisms. Yes, please continue, Jacob.
No, thanks, man. Okay, my point was, for argument's sake, knowing from the construction industry, usually the Association of Arbitrators Association of South Africa is the ones which plays a role in that instance of the construction industry. So what I want to know, if one is aggrieved of the process or the judgment which have been done by an arbitrator, so how can one approach the court to sort relief actually in that instance?
Okay. Generally, the award of an arbitrator is final because of the fact that the parties enter into an agreement for their dispute to be arbitrated. But that's not the end of the matter. I think the parties can approach the court and show good cause why the award of the arbitrator needs to be varied or set aside. It's as I'm saying, the starting point is that the award of the arbitrator is final, and it also depends as well as to the clause. If you understand what I'm saying, that the arbitration is usually a clause in an agreement, right? And if the clause is put such that there is room for intervention by a court in the case where the arbitrator did not did not consider certain material, for instance, or certain facts, or a certain state of affairs, or even a certain case, because there's case law to be considered in some of these things. There's also there would also be certain regulations that may not have been properly interpreted, or a certain piece of legislation that was not properly interpreted in those proceedings by the arbitrator. So there may be instances that it is not so that just because a clause in a contract said our dispute, if we enter into a dispute, we will take our dispute to an arbitrator. It is not so that those parties, they've forfeited all their rights completely to a hearing by a court, because it also depends on their grounds. What are their grounds for wanting to argue with the arbitrator's award?
Okay. No. Thanks, Judge. My point was just to say actually sometimes because I think arbitrators might be looking at the contractual point of view of the agreement between the parties, but there will be other technicalities which they might.
There may be other technicalities that may very well, yes.
Okay. No. Thanks, Judge. I appreciate the advice on that one.
It's a pleasure, Jacob. I don't see any other hands.
You have 4 hands, Judge. You have Nombuso Tolagele, Shelly Malulega, and Jesse Naidu.
Okay. Nombuso?
Hi, Judge. Can you hear me?
Yes, I can.
Okay, thank you. I just needed clarity on sub-rule 8D. I'm just a little bit sketchy with that. I'm just failing to grasp what it means. So if you can please just give clarity on that. Thank you.
Rule 8D of Rule 41A.
Yes.
Let me go to it. 8A, B, C, D. Okay. Let me go and look at it here where it's properly. No offer. Rule 80 says no offer or tender made without prejudice in terms of this sub-rule shall be disclosed to the court at any time before judgment has been given. Remember, when the parties go into mediation, right? There may be some offers or tenders that they make in there on certain points in the arbitration. In the matter, in their dispute, on certain points in their dispute. Somebody might say, my car was damaged in that event that gave rise to the dispute. And then the other side may very well say, okay, fine. If on the part of your car being damaged, we can tender, we offer, or we tender to fix to repair the car, fix the repairs, or to pay for the repairs of the car, etc., etc. But that offer or tender is made without prejudice. You understand? In other words, I'm not tied to that offer or tender. If other facts, or if something else shows that, as a matter of fact, I was not to blame for the damages in the car. Now, this thing says, no offer or tender made without prejudice in terms of this sub-rule shall be disclosed to the court at any time before the judgment has been given. Don't disclose, in other words, don't disclose that offer or tender to the court before judgment has been given, because you might find that in the issues that were adjudicated upon, it came out, the truth came out that I wasn't responsible for the damages in the car. Remember, we went on arbitration on particular points, and then there are certain points that went into litigation. Now, in the process of litigation, you might find that a point that we thought we were to blame for was actually established in litigation that we were not to blame for it. And if we had made an offer or a tender in the adjudication, in the mediation, we would be disadvantaged, and unfairly so, if we had disclosed to the court our offer before judgment had been given, only to find that the judge's findings in terms of the litigation as to the effect that we were not to blame for whatever that happened to the car. Do you get what I'm saying?
Yes, yes, that makes sense.
Yes. Okay. Okay. Good.
Thank you so much.
All right. There are three more.
Khona wangekhethu uTholakele Masikhosana.
Tholakele.
Good evening, Judge.
Yes, good evening, Tholakele.
I just want to ask about the Rule 41A of the High Court rules. Since the litigating parties are compelled to file a notice at the commencement of the proceedings in the High Court to declare whether they are amenable to the mediation of the dispute, I just want to ask, what happens if they fail to file the notice? Are there any consequences or maybe costs, or I just want to find out?
Remember, there is a sub-rule. There's a sub-rule further down that says parties can still opt for mediation. First of all, before filing of the plea and before the answering affidavit, parties may opt. Yes. Parties may opt for mediation before judgment is given. And the judge can ask parties to consider mediation before at any point before the judge makes a judgment, before he hands down judgment, and the judge believes that there are issues here that can be settled, that will benefit these parties if they go out to mediate. If you read through the whole of Rule 41A, you will see, let me just go to the one. In any matter where there are multiple issues, if any issues, except proceedings, the time limits, before judgment, judge. Okay, go to Rule 3B. At any stage, it says judge or case management judge or the court may at any stage before judgment direct parties to consider referral of dispute to mediation, and parties may so refer the dispute. You read that?
Yes, Judge.
Can you see that the fact that they did not make the election at the beginning, it doesn't close the door to them.
Oh, okay.
It doesn't close the door to them.
It's understood, Judge K. I understand.
Okay, all right. Okay, there's two more.
Good evening, Judge. It's Charlie here. My question relates to the labor process. What happens in a case where an aggrieved party fails to lodge a complaint within the prescribed period for whatever reason? Perhaps they were not aware that their condition relates unfair dismissal and they lodge it after. Will that complaint be taken into account, the CCMA?
Well, there's something called condonation. They can apply for condonation, and condonation is granted where good cause is shown as to why you did not lodge your complaint within the time that you are allowed to do so. Condonation is still a possibility. The CCMA does condone. I mean, I want to imagine out of 10 cases that go to the CCMA, at least 4 of them would need condonation. If I were to make a guess, yes, people don't do things on time generally.
Oh, yeah, it makes sense, Judge. Thank you so much.
Sorry, my lady, just to add on Charlie's question.
Mm.
Does that not call for reform of the law? Because we have certain parts of the law that says that you must make an application or lodge a complaint when you become aware of a breach.
Yes.
And then right now it says that when something has happened to you, you have these many days to actually, if I'm not, and I'm not saying that ignorance is a defense, but I mean, we live in a country where not many people are praised to the law. So there's not that call for us to say when a person reasonably becomes aware of a breach on their right, then they should make the application.
Well, I think if we put it down like that, then there can never be any certainty. Everybody will have a reasonable whatever reason, you know. I think the fact that the court has left a door open via condonation, not the court, the CCMA, even the court for that matter. In court, you are sometimes late to file notice of intention, notice of leave to appeal, which is a serious matter, and the judge is able to grant you condonation if you are able to show good cause. It says the provisions say condonation may be granted on good cause shown. Are you with me?
I'm with you.
Yes. You've got to show good cause. It can't be that we are going to open all the doors and say, when you became reasonably, you know, when you reasonably became aware. There are instances, for instance, where the reasonableness of awareness comes in. For instance, with regard to prescription for debts is what is 3 years. And it says when 3 years from the date the debt became due, or from the date when you, as the creditor, must have been reasonably aware that somebody so and so owes you money. Yeah. So even here, there's a back door. There's a door that has been left open, and the door that's been left open is to say, you can apply for condonation of your lateness if you can show good cause.
Yeah.
Yeah.
So I guess my question was a little bit philosophical, Judge, because if there is a backdoor, then that's what we leave to exploit on behalf of our clients, particularly those ones that were ignorant of the fact, because not everyone is appraised to the current standards of the law. So I'm happy. Happy about
Okay.
that.
Okay. All right.
Then you have Jesse, who's next.
Jesse.
Hi, good evening. Good evening,
evening.
Judge. First and foremost, thank you for a highly informative session. It's been really enjoyable on my side. I just
Thank
have
you.
two things to state one statement and one question. My statement pertains to the Rule 41A mediation. I just find that there's a bit of juxtaposition as far as the mediation aspect is concerned. Mediation by its very nature suggests an element of voluntariness between the parties, that they would, of course, be at least adding to some of the aspects of their dispute being capable of being mediated. But on the reverse side, Rule 41A, institutes this per entry provision where it states in every new action or application, the parties must, implement mediation proceedings. So on the one hand, mediation by its very nature is a voluntary is a voluntary process, but on the other hand, Rule 41A makes it mandatory. Now, my question, on the other hand, has to pertain to the rules of court. And it overlaps a bit with the question that one of the other delegates made. In an instance where a party to a new application or an action does not serve the required Rule 41A notice insofar as opposing mediation or perhaps referring the matter or dispute at hand for mediation, would it not constitute an irregular step as far as Rule 30 is concerned? So if I'm on the other side and I'm advising my client, would I not be able to institute an interlocutory application as far as Rule 30 is concerned, which is an irregular step, seeing as how Rule 41A now makes it mandatory for every new action or application to be referred for mediation, or at least be capable of being mediated prior to being fully ventilated in court?
Are you saying, would you not be entitled to a Rule 30 irregular step if such a party turns around and is looking for mediation? Or are you saying?
Sorry, Judge. So basically, what I'm saying is, in the beginning of every action application, you can either say, you can either correspond with your other, with the opposing side, the plaintiff, defendant, or applicant respondent, whatever the case may be, and with your papers state quite explicitly that the matter is capable of being mediated, or alternatively that you oppose the matter being referred to mediation. Whilst I do understand that is not set in stone, at any process thereafter before judgment, the parties can reconsider that position and refer the matter for mediation. But at that initial step, seeing as how the rules is clear and says that every new action or application must be referred for mediation, would it not constitute an irregular step if a party does not set their intentions with mediation known at the forefront?
I think because the rule allows it. Sorry, your name is?
Jesse.
Jesse. I think because the rule allows it, you would not succeed with a Rule 30 application, because the rule itself allows it. The rule, I think also we must look at the purpose of the rule. The purpose of the rule is to encourage parties to come together. So I think courts will be reluctant to punish parties for coming together simply because they didn't come together at the beginning. There's one has to take into account the fact that life happens, under circumstances where I was dogmatic. 2 weeks ago, I was dead against a certain act happening. A number of things may happen in the interim, and you find me in another 3 weeks saying, "Hey, you know what? I'm not so sure. I still maintain the same position." And in court, in litigation or in disputes, it is always a fresh of breath. I mean, a breath of fresh air. Wow, a fresh of breath air. I must be tired. It is always a very refreshing to hear parties showing willingness to come together, to come together, however narrow, to narrow the dispute between the two of them, to do everything possible to narrow or even remove the dispute. So why I'm mentioning that is because a court will consider the fact that the purpose of Rule 41 capital A must not be frustrated. We must always work towards achieving what Rule 41A is intended to achieve, which is to try and get parties to come together. If we're going to throw technicalities like Rule 30 at them when they haven't come together at a certain point, even though the rule itself, some parts of the rule, there are parts of the rule where parties are allowed to decide to mediate, even though they did not do it at the beginning. There's at least one sub rule that I know that I was reading earlier that allows parties to change their minds. Are you with me? Hello. Hi.
Thank you very much, Judge, for that answer. Thank you so much. I really understand the point and perspective that you've relayed. Thank you so much.
Okay, good. Thank you. Thank you to all of you. It's 20 to 9. We've gone 10 minutes over, but thank you so much. It was great having this this discussion with yourselves, and it was encouraging the way in which you all conducted yourselves, and I was really happy, and hopefully I'll be able to deliver something else to yourselves at some point or another. All right, good night to everybody.
Thank you for a productive.
Thank you so much.
Thank you, Judge. We appreciate
Good
you.
night, all.
Thank you. Good night.
Thank you very much,
Bye.
Judge. Have a wonderful
Cheers,
evening.
cheers, legal minds.
Bye-bye.
Cheers.
Bye. Cheers. Zukisa, are you still there?
Thank you, Judge.
Bye. Zukisa, are you gone?
Thank you, Judge.
Thank you.
Thank you,
Thank you.
Judge.
Thanks to all of you. Thank you. It was marvelous.